Those who will have questions are invited to send them in the chats, either on Facebook or here on the Zoom link. And my colleagues will challenge them to us so that we can put them to the speakers as we go forward. We're foreseen to hold this event not as speech after speech, but maybe going with a number of questions from speaker to speaker. And I would like to start with my first presenter, a friend of mine, a colleague, somebody that we treasured a lot until December 2021. We still treasure him as much as before, but he was until December 2021. One of the key members of the United Nations Committee Against Torture. Professor Diego Rodriguez Pinzon is a professor of the American University in Washington, D.C., a university that historically has a very strong link to the torture prevention and protection mandate. His predecessor, Claudia Grossman, was for a long time the chair. Juan Mendez, the former special rapporteur on torture. And I think Diego has been really a very strong voice we had for a very long time in the Committee Against Torture on some of the legal issues as well. And maybe I start with you. So we are the two outsiders in a way to the debate here. And let's start with the outsiders and then narrow in what is happening in Pakistan. From your perspective, you've been a law professor, you've written about this, but you've been in CUT. In 2017, you've been in CUT when Pakistan reported to CUT. One of the recommendations was, as I understand, on criminalizing torture and taking effective steps in implementation. From your background, what are the crucial elements that a state has to take once you ratify? And how can we support this process following up on the recommendations that were issued on Pakistan? Diego, you have the floor.
Thank you very much, Gerald. Thanks a lot for your kind words. And again, congratulate everyone for holding this very important event. This is a very important conversation, as it was mentioned by the chair. It has to be constantly remembered of the need to follow up on what we've done. And I think this is what we have done here. You have held a year ago an event in which I had also the privilege of participating precisely on the same topics. And I feel this is part of a follow-up conversation in this regard. First of all, let me then thank for the kind invitation to the World Organization Against Torture and the Justice Project Pakistan. Again, let me also indicate that we, as it was mentioned by Gerald, hold this specific topic, the prohibition of torture, as a core issue in the broader international human rights regimes. As it was indicated, many of our colleagues in our law school are working in many ways regarding the prohibition of torture. We have and continue to work with courses in our master's degree in human rights and humanitarian law and in our program of advanced studies on this particular issue in different courses. As it was mentioned, some of the faculty invited include civil society experts, members of organizations, international and intergovernmental organizations, so on and so forth. Regarding then your question, first of all, let me mention in general that the state parties to the convention have agreed to confront any form of torture by making it, among others, a crime. Has to be made a specific crime in the national legislation, and investigating, prosecuting allegations of torture, providing redress to victims, excluding statements acquired through torture from all proceedings, and taking legislative or other measures to prevent torture. These are core objectives of the Torture Convention. Therefore, it's essential task of the state parties to undertake it, constantly analyze their domestic legal framework to determine whether these norms conform to the international human rights obligations. In this regard, and based on your question, let me narrow my presentation to one particular topic, which is the criminalization of torture. It's a very important aspect under the convention. and it's an obligation to implement in its national legislation the definition of torture that adequately reflects all the elements contained in the definition stated in Article 1 of the Convention. This, again, mainly reflects in the criminal legislation of the state, considering that Article 4 of the Convention requires every state party, and let me quote, shall ensure that all acts of torture are offenses under its criminal law, which necessarily implies the obligation to criminalize torture as a specific crime, separate from other types of criminal offenses in its criminal legislation. The elements contained in Article 1 of the definition that need to be reflected, Gerald, in the domestic definition can be summarized. One, any act by which severe pain or suffering, whether physical or mental, perpetrated with an intentionally inflicted on a person for purposes as obtaining for him or a third person information or a confession, punishing the person for an act such person or a third party has committed or is suspected of having committed, or intimidating or coercing a person or a third party for any reason based on discrimination of any kind. This is very important. When such pain and suffering is inflicted by or at the instigation of, with the consent or acquiescence of public official or other persons acting in an official capacity. These in general are the elements that should be taken into account when we are dealing with a definition in the national level. There are many aspects that are important in this definition. For example, if we talk about corporal punishment does not fall within the scope of lawful sanctions that have been, do not include in this definition lawful sanctions that are stated in the national legislation. Well, corporal punishment is indeed considered to fall within the definition of torture and ill treatment. Similarly, I think it's necessary to mention that Article 1 includes the abuse committed by non-state actors if public officials knew or should have known that acts of torture were being committed by such private actors, and they failed to exercise due diligence to prevent, investigate, prosecute, and punish the perpetrators. In these situations, the officials should be considered as co-authors, complicit, or otherwise responsible for consenting as acquiescing to such acts. Examples of this obligation under the Convention include the duty to confront violence against women and the so-called honor killings, as well as violence against vulnerable groups, including religious minorities and communities, etc. So I think it's important to take into account some of the aspects of the definition. If you want, I can leave it there and we can continue the discussion subsequently, but to give this very general description of some of the elements and the importance of the criminalization. Maybe at a subsequent portion, I can talk a little bit at the practical objectives of criminalization of torture and the importance it has precisely on what you mentioned at the beginning of your presentation, which is, among others, the reporting to international mechanisms, the importance and relationship between criminalization of torture as an independent crime and the need to adequately report internationally, not to mention the importance of adopting national measures and reporting to domestic, legislative, and other bodies that also exercise powers to promote the prohibition of torture. Thank you.
Thank you, Diego. Maybe I take the liberty and just ask you that second question. I mean, I've seen many countries that have legislated on torture, but they don't use it afterwards. So in other words, what would it take to make a domestic criminalization of torture under the CAT effective? What other measures do you need? And how can the international community support this? And the CAT, obviously.
Well, this is crucial, in my opinion, Gerald, the importance of adopting a definition of torture in terms mentioned before, what I mentioned with the elements, relies on several considerations of a legal and also a practical nature. First of all, it allows the state to adequately respond to its international obligations by being able to pursue criminal action against perpetrators of torture, the basic obligation to prosecute. It also allows the state to monitor the behavior that state officials and determine if the requirements of the convention are being implemented in practice and take any corrective action that may be necessary. It also allows the state to collect specific information about the occurrence of events of torture and how its administrative and judicial proceedings are being carried out, and allows the government to follow up on how the victims of these crimes are being repaired, redressed. So all the elements and obligations basically rely on the existence of a clear definition of torture, criminalizing the law, and that is a reference to basically implement all other obligations under the convention. Is crucial. This information, again, is essential to be able to periodically report nationally and internationally, as I mentioned before, about the measures adopted to confront torture and its outcomes, with qualitative and quantitative information to support such reports. Really, without a clear and autonomous domestic definition of torture, in light of Article 1 of the Convention, the efforts of the state to confront torture and monitor, evaluate, implement would be insufficient.
Thank you, Diego. Thank you for outlining what the foundational notion is, that torture is really, you can't speak of human rights protection if there's no effective protection against torture. It's the foundational notion. You mentioned an event we had last year. It was very much about where does torture occur? It occurs on the streets, it occurs in custody, it occurs in prisons, in policing, in military, etc. So I think it's important that we see this importance and that you laid out the international framework. If I paraphrase your second answer, the criminalization of torture is not everything, but without the criminalization of torture, there's nothing in terms of compliance with the UN Torture Convention. You might not have the data even to say, I mean, every state that comes to the cut is asked how many cases you have, how you have reacted. If you haven't criminalized it, if you haven't defined it, you will not know. And I think we see this in many places. But from there, I would like to go from the more international framework to the situation in Pakistan. And I would like to turn to Sarah Bilal. Sarah Bilal is the Executive Director of Justice Project Pakistan, hopefully very soon a member of the SOS Torture Network. And Sarah Bilal is a partner in many of the work we do, be it on detention, policing, but also the advocacy on cut implementation in Pakistan that we do together. And she is the Executive Director and founder of Justice Project Pakistan, a legal action non-profit organization, and she has also worked as pro bono counsel on many of the cases that deal precisely with torture, not in an abstract way, but in a very concrete protection context. I'd like to give Sarah the floor, and I would like to ask her to tell us from your experience. I mean, I mentioned in the beginning this sort of schizophrenia. We have an international outlawed prohibition, we have torture in practice. What has to happen in terms of the legal framework changes in Pakistan? How important would be the criminalization of torture for Pakistan and in Pakistan? Sarah, you have the floor.
Thank you so much, Gerald. I'm sorry about my video. My connection is not very good. So, I mean, I think Pakistan is a very, very good illustrative case of why you need a law that criminalizes torture. Because the state, even after signing the Convention Against Torture, always maintained that they don't need to criminalize torture because we already have offenses in the penal code that can adequately deal with it. And, you know, they've also set up like certain public safety commissions, et cetera, et cetera. But what Justice Project Pakistan has done through their research has actually demonstrated that that entire framework that was created by the government, which does not contain a specific crime of torture and a specific statute that holds people accountable under international law does not work, right? And we've demonstrated that through the cases that we uncovered, over 1,867 cases in just one district over 6 years. And, many years later, what we found was that none of those people, the police officers, had been held accountable at all, right? So even though the irony is that, I think Sarup will also say this, that Pakistan is a country with a lot of laws, and we say that we're an over-litigated country, but this is one area in which we absolutely fundamentally need a law, because there is no protection for victims. The penal code is not enough to prosecute state officials who engage in torture. And there's been enough data now to show that.
Excellent. I will come back to you. I think there are very important points you've made. I think you said Pakistan has lots of laws, but precisely this criminalization is one missing element, and that's what we see in so many places. And that there is enough data and research that actually makes a very, very strong case. I will come back to you in a moment after we have some of the other speakers coming in. And I apologize if any name is mispronounced, and probably most names will be mispronounced. It's really not on purpose. But I'm very pleased to have Sarup Gias with me, Senior Counsel at Asia, at the Asia Division of Human Rights Watch, who has worked for a long time on Pakistan, the torture issue, including as a member of the Human Rights Commission of Pakistan, one of the well-known NGOs alongside with the Justice Project Pakistan. And I wanted to ask him from a Human Rights Watch perspective, but also from your past experience with the Human Rights Commission in Pakistan, why is torture still there, and how this criminalization could help, and what it would need to entail to help? Sarup?
I'm sorry, I was muted. Thank you so much. In terms of the questions, I'm very glad to be here. My apologies for not having my video on as well because of the connection. I just wanted to make sure that there was no connection problem. In terms of the question that you asked, the first is why there is torture in Pakistan, and the second part being how would criminalization help? Why there is torture in Pakistan has many reasons, and part of the answer is legal, as you heard, that criminalization is the first very important step. But there is a general impunity when it comes to the entire criminal justice system in Pakistan. And part of that, I'll give you an example with Human Rights Watch, is we have documented from a few years ago, we did a report on police abuse. And the striking thing about that was perhaps not that there was torture. That was, there is a torture problem in the region, there's an impunity problem. But it is when we spoke to law enforcement officials or police officials, it was that there was no real attempt to deny that there was torture. Torture has been accepted as a tool, as a method of investigation within the criminal justice system in Pakistan. So it is at the same time, as you say, it's a foundational norm of the entire human rights framework. And in Pakistan's case, I think it's the original sin. It is something that poisons the entire well of the criminal justice system, at least, where we see this as a problem at all levels. The acceptance of first the perpetrators of torture by law enforcement, viewing it as a legitimate tool of investigation. And that speaks to a larger conversation on police abuse and reform and the need for Pakistan to have a sort of a modern, progressive, accountable police force. But it also speaks to a criminal justice system that's broken in fundamental ways. And the torture is both the cause of the criminal justice system being broken and perhaps the most acute manifestation of it being broken. There are laws which enable or even encourage torture. So Pakistan, if you talk about the Pakistani specific Pakistan laws, Pakistan has always had a constitutional prohibition on the use of torture to extract evidence. And Pakistani courts at times have read the guarantee, the fundamental guarantee in the Constitution for human dignity as a protection against torture. But those are, as I said, this is certainly far removed from criminalization of torture. And so what we have seen with the legal system in particular is a complete lack of accountability. And then we have a whole host of colonial laws with the subsequent Pakistan governments have failed to change, which allow for example, a provision for police remand, which allows the police to keep people in custody from anywhere from, let's say, 14 days to 90 days in special laws. And the assumption is that they will be tortured. And that, I think, why there is torture is part of it is because the Pakistani criminal justice system is not modernized enough to rely on any modern techniques, to rely on forensics. It's still a testimony-based system. But I think, and then so there are other smaller problems or contributing problems that one can identify. But at the core level, it is a problem of impunity. It is a problem of lack of accountability. I mean, I can speak on this further, and I think Sarah can, but perhaps even certainly with greater authority on this, given her work. But moving on to the next one, how would criminalization help? I think the criminalization would help tremendously, because the constitutional prohibition against torture, and it's also limited against torture without defining torture for only extracting evidence, amounts to really nothing without a sanction for it. So the first step for accountability, for ending impunity, is at least giving a tool to primarily to the victims, but also to lawyers, to human rights organizations, to even voices within the law enforcement which have a mechanism for holding someone accountable. So for the moment, so the laws are not perfect. The specific law that Pakistan is stable, I think, is very good in terms of the progress that it makes, or in terms of its ambition, in terms of it being in line with international standards. But there are other, specific problems that one can talk about. But what criminalization of torture does at a fundamental level is an acceptance by the state itself that torture is not only legally prohibited, it's something it delegitimizes torture in the public consciousness, in the consciousness of the law enforcement, in the consciousness of the criminal justice system. And in Pakistan, that's part of the challenge. When people talk about torture, when Human Rights Watch was doing research and was talking to police officers, torture was bad if somebody, in quotes, innocent was tortured, as opposed to if torture was, in their words, not mine, if torture led to somebody giving evidence, that wasn't, there's nothing to be embarrassed about by the law enforcement officials in admitting it on record, saying, yes, we did torture, but you see, it worked. That, as I said, again, to repeat myself, poisons the well. And criminalizing it delegitimizes it, not only legally, but it's the first step for delegitimizing it as a tool of political coercion, for delegitimizing it socially in the social consciousness. I'll stop here because there's much to say, and I think other panelists will say much of it.
Thank you, Sarup. It's always a pleasure listening to you. I'm particularly grateful that you've put this issue of the criminalization in this broader context of what it means in the fight against torture. You spoke about some of the issues: acceptance, impunity, the assumption that torture works, that torture is, if used on the right person, potentially right. And I'm also grateful you mentioned the police remand, because I've seen this in so many countries, especially in this region, that if you say police remand or judicial remand, it's almost an equation to torture. And people, even in the legal community, I found sometimes are quite complacent to this. When I ask, so what do you do when you have a case like this? What is your role as a judge in responding to this? I always get a sort of surprised look that I ask this type of question. And I think it's very important that we see the criminalization as a beginning of countering this silent acceptance of torture, a culture change, a criminal justice system change, as you said, a policing system change. And I think we should maybe think of how the criminalization can be part of this broader culture change that we will need to eradicate torture in reality. But I'm now very pleased that I can turn to Chaudhry Mohamed Shafiq. I apologize for the mispronunciation, who is at present the executive director at the Parliamentary Commission on Human Rights in Pakistan. And you may know that the two laws are before the parliament. He was also a National Human Rights Commissioner before. And speaking about this sort of identifying the problem and the culture change that criminalization can do, I'd like to start asking him about two of the works that he has been, as I understand, been quite involved. The Faisalabad inquiry that the National Human Rights Commission has done, and the report, a report that was released in 2019 on torture, which coincidentally, as I understand, had also the aspect of gender violence as a form of torture quite present. The OMCT, with partners in the region, will publish very soon a regional report on this issue, because it's one of those issues sometimes overseen. And I understand that quite a number of the victims that you analyzed had suffered specifically. So I'd like you to explore a little bit on what you found and what the culture change and the legal change is that we need.
Thank you, Amit. Thank you, Gerald, and thank you, JPP, for organizing this very important discussion. As very elaborately explained by Honorable Mr. Rupejaz Saab and the President Speaker Sara and the other speakers, that Pakistan, unfortunately, has turned into a state which has accepted the privilege of torture as a means of governance, I would say that. And this is very unfortunate that the law enforcement in Pakistan has accepted torture as its integral part. And due to this Faisalabad inquiry and other inquiries of the human rights organizations, they have not proved so much effective in getting the police. I would say the Human Rights Commission's reports for the many years, the state of human rights in Pakistan and the other Human Rights Watch, in which Sarup Saab has been working for so many years, they have been highlighting the prevalence of torture in Pakistan. But government could not do or did not want to do something important on criminalizing torture. And when we are coming to your point, specifically to this Faisalabad torture inquiry, this was one of its first kind because it was based on the evidence. It was not based on the news reports. Previously, most of the torture inquiry reports of the Human Rights Organization, even for the international NGOs who have been working in Pakistan, they were based on the basis of the reported cases and on the basis of the news clippings most of the times. But this was the first report which was based on the clear-cut evidence that was the medical legal reports of the victims of the torture. And this was very extensive exercise. I must commend JPP and this whole team for assisting National Commission on Human Rights on that inquiry. And during that process, we also interacted with the police organization, the police officers at the different levels, and then the people from the lower judiciary, and then the survivors of the torture and some of complainants of torture. So this comprehensive inquiry highlighted those weaknesses within the legal and institutional issues of the police as well. Within them, and after those, I would not go into the details of those highlighted those deficiencies, but I would go to the recommendation part because there's a detailed report that's available on the net as well. Our recommendations, you can say, we put forward a recommendation on the legislative angle, legislative reforms angle. Then it was some were the policy reform, some were the institutional reform, and the most important was that due to absence of a legal framework for criminalizing torture, for dealing with the torture, the prevalence of a torture was accepted by the police officers. In more than 600 cases, police, when we interviewed the one interesting thing is that when we interviewed the police officers, when we asked them, do you know that torture is a criminal offense under international law? They said that we know that torture is not acceptable, but they could not answer that torture is basically having any implication on the service. We noticed that, and nobody from the police officers were prosecuted or punished against this crime. Among so many dozens of police officers which we interviewed, when we asked them under which laws you were, the disciplinary action was taken against you, the 90% were against the disciplinary actions. There was no legal action against them. The 90% of the police officers told us that they were suspended, inquiry was initiated against them, that was under the efficiency and discipline rules. And so NCHR report recommended that there should be a clear-cut comprehensive law on the criminalization of torture. Then when we asked who investigated the complaints, one I would that's an interesting part that would also show that the courts sent the victim for the medical examination, and when it was established that he was physically tortured, then after that there was no instance, no case what happened to the victims of torture. The findings of the medical boards, when they were sent back to the courts were unable to do something to the perpetrators of the tortures. They merely sent back them to the police officers, and even no single, they sent back to the supervising police officers, and with the recommendation that action should be, as physical torture has been established against in particular case, so this police officer should be dealt with the law, and he was only transferred and suspended. So there was no independent investigation against those police officers. So we also recommended that there should be independent, impartial investigation mechanism, and then there was no within the police there was no control system. There was no control mechanism. There was no discipline proceeding. Capacity building, we recommended the capacity building police officials should be there. Capacity building of the medical legal officers, that should be there. Then interagency coordination with the coordination between the police, the prosecution, the judicial system, and the medical legal system. There was no coordination amongst all the branches of the government when it comes to the cases of torture. And everybody was passing on buck to the other side, and they were not doing their part, or they were not doing accepting their responsibility. All these issues were highlighted there, and then we recommended that in the proposed law for criminalizing torture, all these issues should be addressed. And if there is something which could not be addressed in the law, then in the subordinate legislation and in the institutional mechanism, which would be in place for implementation of this law, these practices should be ensured that these institutional mechanisms should be in place. So this was about this Faisalabad inquiry.
Thank you so much. I think we get a much better picture as we hear the different speakers. I take in particular one point that always strikes me in other places as well. This is at best you see in many places that people have a disciplinary punishment, or they are put on a different place. But if you look at least with some lapse of time, you see that they are reinstated or even promoted in many places afterwards, which shows that in a way what we're lacking still is a recognition of the problem. And I think the reports that you mentioned are an important part of getting that recognition that there is a problem. And of course, I also thank you for raising this issue of the laws and then the regulations and the guidance and what has to come in addition to that. But I think we're getting getting deeper already. I want to turn now to Rabia Javeri Aja. I'm really sorry for the mispronunciation, but she is the chairperson of the National Human Rights Commission of Pakistan, has worked on prison reform as part of the mandate. I think she worked on a draft mental health bill that is, I think, quite important, on the Bangkok rules and other things. And before we get into the specifics of the draft laws that are tabled and the role also that the National Human Rights Commission could play into passing this and then in implementation, I wanted to ask her also, since we heard now about the Faisalabad inquiry, how much have things changed since? How much can you, as a National Human Rights Commission, use this for follow-up on torture cases or on the awareness raises of this? And maybe because we're speaking with Diego, we're speaking about the 2017 report that Pakistan delivered to the Committee Against Torture. You were at the time at the Ministry of Human Rights. What was your experience? How this process can help? Because one will be upcoming, hopefully very soon, in making the next step in terms of implementation. I'm very honored to have you with us. Please, you have the floor.
Thank you very much for inviting me here and for giving me the opportunity. As a Human Rights Commission in Pakistan, when we face multifarious human rights issues, and I like the word that Diego used, he said, how do you confront something? And I think when you talk about human rights, I think that's the first thing, to confront something, to acknowledge it, to know that it's there, and to move forward. So we look at how can we find the best entry point. So when you talk about the Faisalabad report, the Faisalabad report covers the years 2006 to 12, and it was subsequently concluded in 2019. And the commission that I have just now inherited is about 3 months old. So if we find, and we go back to the question you asked, Sarup, what is the inherent root cause for torture? Find out the root cause and plug into that. So the first root cause is lack of accountability, right? So when you have lack of accountability, of course, then you bring in questions of advocacy on enactment of the law, definition of what the word torture is. There is no clear definition. The constitutional definition is only with regard to extracting information. Then you talk about in accountability, you talk about how do you have independent mechanisms to follow up when police do certain crimes or they perpetrate human rights violations. And I will just divert a little bit to the side to say that the commission itself is quasi-judicial. We have powers of the civil court. We are very strong in our mandate. Over the last, from 2015, we've received 4,600 individual complaints by people, of which 35.7 complaints involve police. That comes to the figure, and of those complaints, a large section involve torture. The rest are involve inactivity or lack of response by the police. So if you see the way the commissions and other independent organizations work, is they send a letter of torture to the IG of the police. The IG of the police responds by saying, we've issued a show cause, that person has had disciplinary action, and then the case kind of closes. And you then never go to the next step to find out, neither have we done it, and nor do many of the independent investigations, look at, well, what happened eventually? Was that guy, did he face the due process of the law? Was he, incarcerated? Did he face any penal action? So we go back to the fundamental question that you talked about, the criminalization of torture. So from the commission, the entry point has to be lobbying for creating these legislative interventions, definitions, independent mechanisms, ensuring this law, this is the 5th law now, if you know the torture law, it gets lost somewhere in the corridors of power. And it's the 5th law, more or less all of them are approximately the same. The second thing which Sarup talked about, and which is also is the deficiency in institutional deficiency in investigative processes. So when the police are under pressure, they, at the lower end of the section officer in the police station has to deliver a statement or get a confession. The first thing he's going to beat the hell out of the guy because he's under pressure to deliver to his boss. So how can you improve the system of investigation? The system of investigation is draconian. The powers are draconian. When you talk about, the taking into police custody under Section 164, 161 statements. So these are quite draconian. Now, the commission, a follow-up of the Faisla Board report would be a good idea, but that would be data and knowledge production. We need to look at interventions within areas that we've identified, lobbying for a law, looking at creating institutional partnerships for investigation. Can we create, for instance, how can we build the capacity of the police? How can we have, just next week, we've become party to a murder case, or not a murder case, a rape case of a couple. And one of the questions we've been asking the government is, what about witness protection? 65% of people who talk about rape or torture rescind their statements. They resile. So what are we doing about witness protection? And next week we have a meeting with Islamabad prosecution to talk about this. People are scared because there's a compromise. How do you come forward against the state? So I would look at creating leverage within the commission. How can the commission be taken seriously? When we talk, can we say, okay, now we mean business? Do we have the resources, the power, the leverage, the platform to mean business? Second of all, can we increase our partnerships? A lot of the police rules talk about independent complaint authorities, none of which are functional, by the way. But can we work with them when they become functional? Can we push to have them made functional? And the third thing, which I think is the cause of torture, is culture. You get slapped when you're a kid by your parents, you get slapped by your teachers, you get slapped by the police. How do you stop that culture of abuse? Or you get slapped by your husband. I mean, how do you stop that slapping? So that's again a role that you have to take, because as a commission, you're setting human rights norms. What are the norms? And so it's a huge task and it's a very huge question, but I hope I've sort of...
I think you've put us on the right track. I like very much the way you say how we confront a problem and the different layers, looking at the root causes, looking at accountability, trying to build mechanism, including within your mechanism, the investigative process, the broader culture change. And I think one element that we might want to discuss, or the two elements I might come back to you as well, is on the witness protection, because I often see that if we look at the torture laws, anti-torture laws, it's relatively clear. There's the outlawing, there's the right to remedy and reparation. There is the recognition that torture is different as a violation to other violations in what it does to people. It is a lifelong impact on people's lives, on their well-being. And what we see is that often legal processes are re-traumatizing processes because you're up against a wall of opposition rather than having a system of support. And I always remember in early days working more on a trafficking issue in Europe, at least, where suddenly there was a recognition that people have to have a formal recognition as a victim with protection that goes with it in order for them to be able to walk through the legal process that were coming. I always wonder whether some of this learning would be relevant also for the anti-torture struggle. But I will come back to you on those issues. I think you've set them out beautifully. And I wanted to get back to Sarah because Rabija, you've said it's the fifth law that got lost, or the fifth law and on torture, and the others got lost in the corridors of power. So I wanted to ask her what, and I know you have worked personally on this. I even remember doing joint submissions with OMCT on some of the previous laws where I thought maybe it's close to come this time. What makes you believe that this time is different with the private bill that is tabled, but also the government bill? Are we in a better position to push this through? Will this see the light? What gives us hope?
So I'm a believer of hope anyway, but I think it takes time and it takes strategy. I think the truly unprecedented part now, as opposed to the previous bills, is that for the very first time, the government itself has tabled a bill. So all of the bills in the past have been either by opposition members or by individual members. But for the first time, we've seen the state, through the Interior Ministry, actually draft and present a bill. That is a very promising development. Now, it's unfortunate that the government itself now is in flux. But, whichever government comes or, whatever opposition party comes or this government stays, the truth of the matter is that you have seen now cross-party support on the issue that there needs to be a bill, right? So there was a bill passed in the upper house and the government itself has a bill in the National Assembly. That makes me very hopeful that whatever political situation emerges, the momentum for this law will not be lost.
Excellent. Let's hope this, and let's go to Sarup as the next. I mean, just following up on this, let's talk a little bit business on what do the two laws actually provide, how far they would go, and what the challenges are for making these laws pass the ramp and not getting lost in the corridors of power or of power politics between different ministries. Sarup?
Hi. Yes. Yes.
Okay,
I'm here. Okay. In terms of, I think what Sarah has said, I am also cautiously optimistic at this point. I mean, partly because there is no other choice but to be. I think it's an important step, though, in terms of the substance of these laws. So, in terms of what they seek to do, I think this law goes well beyond previous attempts of trying to do this, which is both in terms of definition, both in terms of what I think in line with international definitions, with CAT. I think Pakistan has, it talks about sort of, both psychological torture and physical torture. I think that's an important thing. It talks about criminal liability for a public servant, both intentionally and or negligently. So I think there is both to cause a custodial death. I think it's an important step. That's a slightly separate but related issue. And I think in terms of the text itself of these attempts, I think there has been movement. So it is a law which by no means perfect. It talks about, it at least tries to bring it in line with both Pakistan's international commitments and to sort of realize the constitutional guarantee. So there is gender protection, there's sexual violence, sexual abuse, is irrespective of sex and gender. And these are things that, in the Pakistani context, I think the drafting of the law built consensus, and I think it built bipartisan consensus across the aisle with both government and opposition, at least with sort of key members. And I think that's an important step. In terms of if it will go through and if it will get lost in the bureaucratic maze, as you rightly pointed out, and Sarah has pointed out, and sort of, previous speakers have talked about, I think I'm slightly more hopeful. And partly why I'm slightly more hopeful this time, because, advocacy efforts do incrementally change. So the government's position, I think ratifying CAT was important. I think the promise to define and criminalize torture in June 2022 as part of Pakistan's candidacy for the United Nations Human Rights Council was important, because these are public commitments. In the GSP Plus assessment with the European Commission, again, the fact that the Pakistan government engaged, and the fact that in the February 2023 report, it was flagged, I think those are important things. I think even domestically, an effort led by many of the people on this call. I think by somebody like Shafiq Saab and Rabia Javedi Agha Sahiba. I think these are important voices, and I think and Sara, of course, and JPP. So I really do think that there is a moment where the realization of at least enacting not only a law, enacting a law which does not check the box only of this is an international commitment that we can no longer defer, we can no longer sidestep, be evasive about. I think it goes beyond that. And I think there is buy-in. My feeling is that there is buy-in from people in the bureaucracy, people in the police in particular, I've seen, which they do feel, many senior officers in the police do feel that, there is a larger police reform conversation where torture forms a part of it. So it could be framed in resources, in independence, in autonomy, and with that, to bargain that with accountability. I think there is a moment where it is possible. Having said all of that, having said, as I said, it's cautiously optimistic. There would be further challenges. So this would be, as has been said earlier, is the first step. This is where another segment of the struggle begins, because part of this enforcement of torture, so be it the Federal Investigating Agency, be it police's internal accountability or other law enforcement agencies, internal accountability mechanisms, there is a problem there. There is a problem of oversight, of giving the power of enforcement, giving the power of implementation of these protections against torture to the same institutions whose members, so not institutions as a whole, are also complicit in the problem. But that's a problem elsewhere as well. Those are problems that would need sort of addressing at some point, where some mechanism which is independent will have to be structured. But for the moment, I think given the laws that we have seen, I think progressively, the government's position, progressively, the political class as a whole, as I said, government and opposition creating buy-in with people like Shafiq Saab, the people like Rabia Sahiba in sort of, in important positions, that does inspire confidence.
Excellent. And I'm glad you give me hope. I'm very pleased to hear about what you see as the advances in comparison to the previous laws. You mentioned the further steps that will be needed in terms of independent bodies, and you spoke of Rabia as one of the influential voices. I want to go back to one of those influential voices, Rabia. You've spoken about the impunity issue before. You've spoken about independent investigation. You have an independent mandate. As far as I see, and I understand this might be also a problem in Pakistan, we often have, as Sarup mentioned, the same institution basically investigating its own abuse, which often fails because the institutional interest is not there, to the contrary. Or we see, especially in Asia, a lot of immunity clauses that prevent that certain actors, like the military and others, are basically exempted from investigation because the civilian authorities might not have authority over them. Or in India, where you have the special clauses of the Armed Forces Special Powers Act that is a guardian of impunity for such a long time. How can we prevent this, and what role can your National Human Rights Institution creatively do, and how can we support you in playing this role?
Okay. Thank you. First of all, the various police acts that have come into existence do talk about setting up organizations or committees to address police torture. But as Sarup very well said, they come under the hierarchy of their own organizations, and by and large, they are dealt with under police efficiency and discipline rules. So rather than facing a criminal thing, they are normally prevented from being promoted, or they're suspended, or they're transferred. The KPK, which is one of the provinces of Pakistan, has just passed a police act in 2017, and they set up independent regional police complaint authorities. And these were manned by bureaucrats and judges and people from the private sector. And funnily enough, they were not made operational. And now there is a move to actually remove those sections and create a separate independent police authority bill, again under the police, because they did not want that mechanism or and the new bill actually removes and erases the earlier sections which talked about the setup of the independent complaint sets. So the police are very territorial about their space and not very keen to give it up. You will have to create, and as I'm telling you, in our past, the commission would always send these a large number of the cases to the police, but we would get this very simple letter saying disciplinary action has been taken, matter has been seen to, officer has been suspended. And we never did the second step. Now, as far as the commission is concerned, its powers are quite extensive. I've come from the government ministry, and I have been bowled over by the kind of powers the commission has. So if you look at the National Commission in relation, and we did a comparative study of the other commissions throughout the world, we have the powers of court. So we can take in, we cannot pass the penal punishment, but we can certainly investigate crimes. We can certainly call for documents. We can record statements, and then we refer them to the relevant court. Of course, that needs a very efficient complaint management system. We are strapped for human resources, and our complaint management system is basic. So, you know, when you're looking at, and I think one of you mentioned, I think it was Diego talked about data. When you have that kind of information, also how complaints coming in, how do you use that data efficaciously? How do you do it to implement change? So from the legal perspective, we have this you know, a quasi-judicial power. We also have the power to, as a watchdog of the government, to recommend to the government, and that is somewhere where already Shafiq Saab talked about the role of the report. How do you leverage that report? How do you look at, and again, this is because we're very new, how do you create partnerships to ensure safeguards to, for instance, custody of victims? When prisoners are taken, how do you ensure the safeguards of that? We had worked with Sarah on a mercy petition when we were in the ministry, and we found out that every province had a different little form to fill in a mercy petition for death row prisoners. And because it was so archaic, we developed a computerized template to actually, in which there was no brain power involved. You just had to tick the boxes, and we sent them to the police stations. Can one do that, for instance, in the medical legal? Create that. I know there the Istanbul Protocol does talk about it. Can we create that template? Can we ensure that there is no brain power involved and people can fill it, and that kind of data is recorded? We were also involved in witness protection, is something that I'm very, very disturbed about, because two of the cases that we forced ourselves to become a party to, one in fact was the torture of a feudal lord who killed a peasant who objected to hunting in his grounds. The wife has resiled. She was fighting a murder case and she's resiled, and this happens all the time. How do we protect these people? So, you know, it's a huge plethora, but I think we have the power, we have the legal power. How do we get the resources and the data and infrastructure to manage it? is something we will have to work on.
Excellent. In my early professional life, I was involved in helping to set up some national human rights institutions in Eastern Europe and in the former Soviet Union. One of the challenges was what you described initially, that they could send a letter to the authorities asking for information, but function more as a post box. I find it extremely encouraging to see that you have this quasi-judicial function, that you have these investigative powers, and I think that's a tool to refine and to use, which is of great potential. So I'm very encouraged to hear this. We have collected a number of questions. I've seen also in the chat some additional ones. Before I ask additional questions to each of you, I feel I have a little bit neglected Shafiq, and I want to come back to you. Also because at the time of the cut report, I understand you were basically part of drafting the government's report to the Committee Against Torture. Now, we have a new step coming up. I understand there's some delay because it's actually already overdue. But how important can this momentum of the second reporting to cut become, both for this law, but also for its implementation?
Thank you very much, Gerald. And before coming to your point, I must appreciate the cooperation Ms. Rabia Javedi Agha has been extending to the Commission as a Secretary of Ministry of Human Rights. I'm taking this opportunity to publicly, I would say, acknowledge and appreciate her efforts at that time in supporting the National Commission for Human Rights. And then, as NCHR, we have high hopes on her that she would be obviously taking this very important task of monitoring government of Pakistan's compliance to human rights standards and human rights obligations from the NCHR platform. Now, coming to your point, this state party report is a very important. This state reporting to the CAT is a very, very important process. Basically, from my point of view, from as a human rights defender or as one of the contributors to the state report, I see it's an opportunity to reflect on ourselves, basically, as a stakeholder in the process of prevention or eradication of torture. After a certain period of time, we have to report to the UN system, and then at that time, if we take it positively, if we take it with a healthy spirit, then we can reflect upon that where we left at the previous time of reporting and what we have achieved so far. So 2017, now there are three benchmarks. 2010, when we ratified the convention, then 2017, when we reported for the first time. Now it's after 5 years in 2022, when we'll be reporting for the second time, and then to the UPR at the same time. So where we have come so far for the legislation, this report will give, I think, support to the advocates within the government and outside the government, that why we need a strong anti-torture law, and why we need to remove the deficiencies of that anti-torture law, which we all have been talking about at the different forums. And then the third point, which I would mention, that the state report basically is not this is a misconception among the government officers. Majority of the government officers in the Pakistan, and I think it's same with all the third world countries. They think that when they are reporting, they will be examined, they will be judged, and there will be some sort of judgmental verdict against their performance from the UN bodies. So they need to understand that this is sort of engagement to improve that particular aspect of which that report is talking of. So when we will present our second report from this intention or this context or this state of mind, that we will seek guidance from the UN experts that how to improve our situation with their experience, and we will share our truthful situation, and we will share the correct information to the experts and seek their guidance. I think then this dialogue will be very beneficial. But if we will take it in that way, that we are going to the UN body and we are going to present them some sort of we are appearing in an examination, we are taking a test, and we will have to score some sort of marks, and we will have to get in grade A and B, and we'll get good name from the government. This will not work. This will definitely not work. This will be against the spirit of this whole process of reporting the UN experts and getting the guidance and support from the international community.
Thank you so much. And it's also a little bit our experience working at the OMCT that countries that come with an open mind, that actually see this as an opportunity, or where I think also authorities within the government, because governments are not monolithic, see this as an opportunity to make things pass where they are maybe at the edge of being passed. I think governments that come with that attitude actually get out of the process usually much nicer, because it's much more valued as well by the committee. And of course, it provides a basis also for cooperation with civil society, subsequently with the National Human Rights Institution, to really make a difference. So I appreciate those comments. There are a couple of questions we've collected. I will try to pass them a little bit arbitrarily, but if any of you, while we go from one to the other, feels that there's something that they want to follow up on a previous one, please feel free. So since Shafiq had mentioned the role of CAT, I go back to Diego. You gave us this introduction in the beginning of what criminalization means, what the CAT perspective is. Now that you've listened to everything, on some of the other issues, investigation, policing, accountability, what other things do you think we have to keep in mind? Is there a sort of particularly good practice on what a broader law on torture and implementation can be? Is there some experience on who should be, this was one of the questions raised, who should investigate police abuse on torture and the like? Please.
Thank you, Gerald. Yes, listen, I've been listening with much interest, the discussion, and of course, what you begin to see is a common concern that indeed reflects, for example, the concluding observations of the committee. If you remember, the committee in the concluding observations in 2017 already had a very specific emphasis on certain issues of concern, and you can see it reflected on the follow-up question, the follow-up issues selected by the committee, in which there had to be specific emphasis. If I remind you, regarding the allegations on widespread use of torture by police, specifically, the committee indicated that it was important to ensure that the police who engage in torture are prosecuted and punished with penalties that are commensurate with the gravity of the offense, as well as, for example, concern on inadequate investigation and complaints of torture. Again, we are in that same realm. We are talking about accountability on that particular issue. It focused on taking immediate measures to ensure establishment and effective operations of effective police oversight bodies, particularly public safety commissions at the district provincial levels throughout the state party. And similarly, the third issue, which I think is important to remind us about, deals with impunity, the acts of torture of military and paramilitary forces, intelligence agencies, indicating that it's not necessary to take measures to ensure that all allegations of torture and ill treatment are promptly, thoroughly, and impartially, extremely important, investigated fully independent civilian bodies. These are, issues of specific concern of the committee, and that serve as a template for a conversation after 2017, and again are relevant, of course, if we are talking about the new report by the state. In this regard, I'd like also to refer to the committee's reference when talking about specifically the obligation to establish a criminal provision in the national level. In the concluded observations, the committee also focused on the importance of an appropriate penalty, the proportionality of the penalty, which is linked intrinsically to the importance of the stigmatization of the crime of torture, in which not only the crime should exist, but there has to be appropriate and proportional penalties to the gravity of the crime. And that's, I think, very relevant when we are thinking in establishing a criminal provision in the national level that requires that. Again, best practices regarding your question, Gerald, there are, I would say, several models that have been implemented to respond to this obligation. On the one side, what I call the mainstreaming of the torture criminal provision in the criminal code of the country. You know, with one of the conducts that is singled out in the criminal code that is used in a daily basis by criminal practitioners really sends out important measures of the gravity of this crime. On the other hand, that states have also used specific and independent laws to implement and to, again, single out the need to take comprehensive and holistic measures against torture. That includes the criminalization and many other measures that are in some cases implemented in a comprehensive law, anti-torture law. So again, this is something that states to a certain extent may decide to use in one way or another, and each one has its own benefits and challenges. Finally, let me mention a couple of issues that I think is important to also remember when we are talking about the establishment of an anti-torture law regime or this type of measures related to the criminalization, which is to never forget the victims. Crucial, the central objective of the measures taken both national and international against torture are geared towards dealing with the horrible consequences of torture. And victims, I do believe, are in the center of the International Convention of the United Nations Convention. I call to your attention Article 14. There's a general comment of the committee on this particular article. It shows all the different aspects that inform the obligation of the state to provide redress, comprehensive redress, a quite unique comment among other international bodies that should serve as a very important reference when talking about all the elements of redress for victims. Again, this is the ultimate objective. And finally, just to make echo what Rabijan was saying and other colleagues regarding the importance of national, very national, new and specific measures regarding torture, I do believe that when we talk about provisions like the one in the convention that deals with the obligation to train public officials, the prohibition of torture and other aspects, one mentioned the Protocol of Istanbul, among others, I do believe that this very, very granular approach to it is extremely important, not just to talk about formal education, but the instructions, very specific instructions that are given to public officials should be part of the conversation, how they are implemented, the protocols to deal with very different circumstances. You are talking about persons in detention, in mental and psychiatric facilities, etc. All those spaces, the specific rules that govern and instructions should be dealt with both nationally and internationally. And again, they are always part of the conversation in the review in the committee. Just wanted to touch upon 2 or 3 aspects. Gerald, thank you very much for the opportunity.
Thank you. We have about 13 minutes left. I want to go back to each of you. I mean, you've highlighted a number of important things, I think. On the investigation, clearly, it's not the authority, it shouldn't be the authority that is responsible for the breach. And very importantly, civilian authority has to have authority over whoever, the military and others. I think this is an important point. And of course, the victim side, because sometimes we speak about torture in very abstract ways. And I will come back to this point. But there were a couple of questions already in this line of what you say about the ineffectiveness of implementing law. I mean, we know countries that have lots of laws and nothing happens. I think this was the essence of one of the questions. When I listen to you, Diego, I have almost the impression that beyond the law, we need an additional action plan on the law. And on this, I'd like to go back to Sarup, because he has spoken on this broader cultural change and the importance of the law. But what beyond this law would we need to see afterwards? Would we need an action plan or whatever structure? What do we have to think about to make this then effective?
Thank you. I think in terms of what we need after the law is made, there will be, I think there will be at both levels, the level of an action plan which comes from the government, from the authorities, in terms of ensuring implementation or enabling an implementation. By that, what I mean is that given the challenge and the enormity of it, what would be required is firstly a sensitization of the criminal justice system at all three levels, at the level of the investigation, at the level of the prosecution, at the level of adjudication. So starting from the sub-inspector or assistant sub-inspector of the police to judges of the Supreme Court, essentially in Pakistan, for them to be, for want of a better word, educated on this, or one can choose sensitized on this, I think is very important. And it's easy. I mean, it's only possible when there is a law, because, and then the task would be for the non-governmental task. Of course, there is a societal dimension of it, which requires, which is a very broad canvas in terms of first making people aware that this law exists. In Pakistan, there is a challenge with many progressive legislations that Pakistan has done, is to make people aware that simply that this law exists. And the third, I guess, would be in terms of an accountability mechanism, an enforceable, tangible, and even if a quantifiable mechanism of measuring progress. And there are, I mean, you would know this better than I do, and there are examples. What you said in your introductory remarks, for example, or I think somebody else said that if once you have a law, what it does, it allows for documentation. It allows for, even if imperfect, it makes the government at least record, and to push for that kind of documentation, to hammer home the point, like JPP has done in the past, like the NCHR does, by reaching out for representative examples of how prevalent this is, how deep the problem is. So I do think that there is a lot of work to be done once the law is passed, both at the level of legally enforceable structures or reporting mechanisms, at the level of sensitization of the criminal justice system in general, in particular, and then an attempt at, societal awareness in general. But all of this really starts with the law, where it is a tool. And then for civil society organizations, for human rights organizations, for lawyers to be educated, essentially, or to be prompted, encouraged, enabled to use this as the tool of accountability, as the tool of holding the feet of people in authority to fire.
Thank you. Thank you. I mean, clearly we have lots to do once this law is passed. So I'm already rejoicing of having more of these discussions in the future, hopefully after the law has been passed. But I wanted to go back to you, Rabia. There's a question here, and maybe in the broader sense of this culture change that is needed, and of course you are a key mechanism in a way for this. There's a question about moving to a broader topic of torture or torture's punishment, which is still part of the justice system. How do you think we can coincide culture or religious interpretations with a movement towards more humane approach in punishment? What steps can be taken in this regard? I don't know whether you're the right person for this question, but maybe to frame it more in terms of how this process can change the culture, be it on gender, be it on women, be it on minorities, be it on a religious interpretation. I think you're mute.
I said I'm going to again quote Diego because I love the statements he makes. Put the victim at the center. So if the victim is at the center, we talk always about accountability police, but, does that victim trust the system? Does he want to go up and say, here's the huge state machinery. Do I have the courage to face that machinery? I give you an example. Recently, we've been very involved in hate crime against transgender person. About 70 people have been murdered. And when we call for the official police statement, they say 25. So That's because people don't go up and complain because they don't trust the system. It doesn't come into the database of the system. It doesn't exist. So how do you create that trust? Again, that's a huge core responsibility that the commission, if it wants to take these cases, will have to develop the trust. Second of all, how do you ensure the protection of those people? How do you ensure that they're not going to be picked up, they're not going to be persecuted? How do you ensure their safety? And third of all, how can you ensure to those people faith in the system, that the system will deliver? That all this noise, this expense, this anxiety of going to complain, will it have a fruitful result? And there is, of course, hope, but it's a huge task. And this is something, again, I'm throwing to you because I'm not very, for instance, we're always talking about the police, but our recent investigations based on a particular case in Islamabad was government mental homes. How do you address that? That really is one of the most vulnerable sections of society, of people who do not have the cognizance to know what is happening to them. And that's something we are at the commission, because of a particular case, is that there's no mental health regulatory authority in the federal capital of Pakistan. And that's something we're looking at very actively. So I don't know if I answered your question entirely, but there's much to be done. And I think the fact that we have this conversation is a great way to confront it. Thank you.
Thank you so much. I really like what you say. Does the victim trust the system, or does the victim trust or fear the system, we could say? I think it's a little bit the litmus test of what will come with this law and how it works. But it's true that often, even in the anti-torture world, we speak very much about mechanism and structures and institution and laws. But in the end of the day, if there's not a victim recognition, and if it doesn't serve those that are vulnerable in community, and this is, I think, an important connection, it will be very difficult to achieve. But thank you for this. I wanted to go quickly back on a similar note to Shafiq, because one of the elements I understand in your inquiry that you were engaged was the vulnerability of women and gender-based violence. And I just wonder whether this is one area where you could say a few additional words before I go to Sabra for closing.
Yes, Jared, I agree. Basically, the gender-based violence needs to be looked into as it has been interpreted by the United Nations Committee Against Torture. And somehow, because the various aspects of the violence that has not been linked to the torture debate generally in Pakistan. There are two deficiencies when we debate the issue of torture in Pakistan, that torture is only linked to the policing, over mishandling by the police and the physical mishandling of the police. So all the other aspects of gender-based violence, which should be considered as torture due to their gender vulnerability, basically, they are not addressed in the torture debate or at any policy level in Pakistan. So I fully agree. When we investigated the Faisalabad incidents of torture, when we looked into those cases, many of the instances about the women victims of the torture were because of their vulnerability and because of their gender identity, that they were subject to that almost in all the physical aspects of the torture, or of the mental suffering, that was because of their gender identity, that they were exposed to such situation. So I think, very unfortunately, the present law, which has been, although it is a very welcome step by the government of Pakistan, and the present draft, which is under discussion of Parliament, that also excludes this part. And so I think one of the challenges for the human rights advocates would be, during the next step of legislation, would be that this law should be addressing this part of torture due to the gender identity, should also be included in that.
Thank you so much. I think this is an important point for the follow-up work we all have to do. I'm very happy that you raised this. As we are coming to an end, I want to ask Sarah, as sort of co-conspirator on this meeting as well, to maybe have some final words, and also from the perspective of, I mean, you have we are speaking about victims, vulnerability. You have represented people in legal proceedings that were subjected to torture or even death row, etc. What is the final perspective you want to give from that perspective on what is ahead of us here?
Thank you. So, I mean, I would just give one anecdote that I think just sums it up perfectly. You know, for 20 years that we've been doing this work, right? I have not been able to successfully get redress for even a single victim of torture, right? The stronger the proof that I have that the victim has been tortured, the more likely it is that he will be forced to compromise with the police and drop the charges. This is why we need a law that criminalizes torture, because we cannot prosecute anybody or hold any perpetrator accountable under the current legal framework.
Thank you, Sarah. It's not precisely a message of hope at the end, but clearly it's a message of necessity for this law. And I think what all this discussion with all of you has shown, that an anti-torture bill is required, both legally under the Convention Against Torture, but also as part of a much longer and broader process of recognizing a problem and addressing it in the multiple facets that we have. And I think that's important, that we carry this message out as well to the broader audience as we speak to, that torture is not only a niche issue, a humanitarian issue. It's intrinsically linked to who we are as a society, who we are as a state, whether we are trusted, whether we are feared as state institution, and it's intrinsically linked to culture, it's intrinsically linked to legal cultures, to the rule of law, criminal justice, and many of the other issues that you've raised, from policing to religious to whatever it was. I think this is an important step that we move this forward, and we hope that this meeting could contribute to understanding this issue in a broader sense. And we are certainly, as Justice Project Pakistan, but also as the OMCT, committed to work with you and try to see whatever way we can help that this first step is taken, and then to walk the street that has to be gone after that. I'd like to thank all of you for your presentations. I'm enlightened and delighted, and I'd like to thank the teams of Justice Project Pakistan, and of course my team as well, with Nicole leading it, for convening this, but also being for the intellectual mind behind this, and of course the force de frappe to make this work, and to have hopefully future discussions like this, where we speak about how we can perfectionize the implementation of the law once we have it. A big thank you to all, a real pleasure, and a good morning, evening, afternoon, wherever you are, as we go forward. Thank you.
Thank you.
Thank you.
Thank you, everybody. Thank you, Jared.
Thank you.
Thank you.